to the Truth Legal webinar, all about resolving employee disputes under the Employment Rights Bill 2025. Today we've got Navia Shekhar and Mirik Zazarik to talk through what you can do if there is an employee dispute and how they're going to work going forward once the Employment Rights Bill is passed and it's all been implemented. If you've got any questions about how it relates to your particular business or any question in general, then we'll have a bit of a Q&A at the end. Please put them in the chat, or you can ask them at the end as well. So the three big changes that are going to affect the employment disputes under the Employment Rights Bill will be the increase in time limits, changing from 3 to 6 months for the employment tribunals, the introduction of the Fair Work Agency, which will be enforcing employment rights, and stronger union protection and recognition. So firstly, on to the change in time limits. Navia, to you, what are the practical effects on employers and businesses for the change in time limits?
So at present, if there is an employment dispute between an employer and employee, an employee has 3 months minus 1 day within which to bring a claim or initiate the claims employment tribunal claim process. This is going to change from 3 months to 6 months. So that will be 6 months minus 1 day. Gives a longer period for employees to pursue their claim. It could mean potentially more claims, and it could mean potentially longer periods of uncertainty for employers, because this gives the opportunity for employees to seek advice, get their head around the issue, get advice, and pursue claims. Financially also, it makes it more viable for them. They've got a longer period to find resources to try and pursue such claims in the employment tribunal. This could possibly also give, rise to more spurious claims because, again, it's long-drawn process. They can, cause more disruption for businesses by engaging or advising the businesses through ACAS that they are going to take tribunal action against a business. So that is likely to impact businesses in terms of the number of claims that are going to be there, the uncertainty, the longer period of uncertainty whether a claim would be brought against them or not. And overall, a business will potentially not be able to function the way they, with this hanging over their head. They have to address this when they want to be running their business rather than having to address legal issues. But that's what the potential impact can be on businesses of this this whole situation.
Okay, and Mirik, how do you believe this will affect the employment tribunal cases more generally?
Yes, it will affect in a sense that the process will be longer. Probably there'll be larger number of claims being made, because currently, for example, if someone was dismissed 4 months ago, they, let's say, contact Truth Legal to make a claim against a business, we would say the claim is out of time, so there's basically too late to bring a claim, and that resolved the situation. While now there will be, in the near future, there will be 6 months. So what that means, the employees who may not even think about a claim, they may talk to someone in the near future, they will say, oh, actually, I've got a claim, so I still got time. I mean, within the 5th or 6th months, I can start the process. So we've already seen an increased number of claims in the employment tribunal, and the sort of average waiting time for a final hearing is anything between 18 months to 24 months or sometimes even longer. So it's already increased. ACAS is overwhelmed with the number of cases, and that also will affect the system. So as Navia mentioned, it's sort of like it will be an ongoing situation where there will be basically more claims running in the background. That's what I think, and that will also affect the businesses in terms of legal costs and having the means to defend such claims.
Yeah, I mean, just to add to that, it is not something that necessarily is a topic within this webinar, but the government's proposal is to bring something else called Day One Right, which means there will be additional claims, and that will also add to the business, the impact on the businesses. So all of these bits that Mirek has mentioned, there'll be additional claims that will come in, that are likely to be coming towards the businesses.
Okay. So more claims, longer claims, more costs.
Yeah.
Yeah. Okay.
Well, just to add to this
Yeah.
from practical perspective, because I do take a lot of quite often in preliminary hearings, I do talk to judges, so they already struggling with the number of claims and cases. So the system is basically not designed
Ready. Yeah.
to sustain these changes. So I just don't know what is the government planning in relation to sort of catching up with the judicial system with this new bill, because one is not really ready for another at this stage. So we will need to sort of monitor, observe what is going to happen. But I think it will be a bit of a chaotic in the first year or two. That's for sure.
Yeah. Okay.
Yeah.
And on to the Fair Work Agency. Navi, could you just talk us through what the government has promised with this? What have they said will be delivered from the Fair Work Agency?
So the idea is the government is trying to sort of compile a few different agencies that exist at the moment, but I don't think that these agencies are very effective. So there are various different agencies that exist at the moment. For example, Employment Agency Standards Inspectorate and HMRC's National Minimum Wage Enforcement Team. Usually at the moment, their powers are limited to dealing with complaints and then imposing fines. What the government's proposal is to combine these agencies and put them together, so there'll be one agency which will be called Fair Work Agency, which will be dealing with the complaints. They will have a little bit more, let's say, powers to implement where the businesses are failing. They will have more power to implement compliance by the businesses. So they will be in a position. So where if any business is not paying national minimum wage, or if statutory holiday pay has not been paid, or if, say, for example, there's statutory sick pay, those sort of bits will be addressed by Fair Work Agency. The other thing that was going to happen is that the Fair Work Agency will be able to pursue claims on behalf of employees in the employment tribunal. So a power that did not exist before. So whilst they could deal with the complaints and address them to a degree and impose fines on the businesses, now they will have more power by which they will be able to make orders to say, well, you've got to pay the minimum wage and pay the back wages, whatever that would be. Make sure that they've paid them their statutory sick pay, and they've paid them the correct holiday pay. But not just that, if there is scope for this to be progressed for civil litigation in employment tribunal, they will have the power to do so on behalf of the employees. So the compliance, it is crucial that businesses make sure that they have a process, they have that they've set up in place, and make sure that people are not being underpaid accidentally being underpaid. Perhaps regular audits would be a good idea to ensure that they're not caught inadvertently caught by Fair Work Agency. Puts a lot more onus in some ways on the businesses to ensure that they're complying with every single aspect that is required with statutory holiday pay or record keeping for holidays and sick pay, national minimum wage. I mean, these things are things that an employer is required to keep, maintain anyway, even today. But because enforcement is difficult, it's employers are able to get away with it, which is unlikely to be the case going forward. So that's my my take. But again, we don't know how exactly this is going to function going in the future. We'll see how that would be, and how the government proposes to implement and how this will actually work in reality. But that's the position at the moment.
And Mirik, how do you think this will work in practice? How do you think the collection and enforcement through the Fair Work Agency will operate?
Well, I think that as a business, it's just best to be prepared. So you need to have all the handbooks, employment contracts, policies in place. If someone brings a fit note from GP, you need to make a decision. Do we have to pay statutory sick pay or a company sick pay if that is contractual? If someone is leaving the business, then you need to make sure that a notice pay is paid and the accrued and unpaid holiday is paid, and then any time for sickness as well. The idea so far from what we hear about the Fair Work Agency is that they're going to deal with the statutory sick pay, mainly the national minimum wage. So sometimes for national minimum wage, especially for the care industry, the questions are usually what is the travel time, what is the working time, what is the mileage for traveling. And sometimes when you sort of like not clear what is the national minimum wage, I believe this Fair Work Agency may step in to resolve. So obviously now, if let's say hypothetically employee is not paid, then the employee needs to make a claim. Well, I believe that they may contact this agency and the agency will help this person to resolve it quickly. How this is going to work in practice, we don't know yet. Because we don't know if they're going to actually have the power to make a claim, or they're just going to be acting as ACAS, as some sort of a pre-court negotiators, where they will contact the business and they will try to resolve it amicably. So I think it probably will be more of a deterrent than active body, but we'll see. But the best defense is to make things right in first place, and then if you don't have any issue, then there will be no claims. But that's what I think. I don't know, Nadia, if you can add to it.
Yeah, but like just what you said right now, Marek, in terms of care industry, for example, and the various different components that form people's part of their wages, but the employer may be unclear as to whether how that's sort of pulled in terms of, say, national minimum wage. So the best way to deal with those sort of things, even if there might be circumstances where it's ambiguous and you're not unclear, the best way to sort of keep on top of these things and avoid any potential comeback on businesses would be to make sure everything is properly recorded in terms of how people are being paid and the reasons behind it. So if there is any changes or any additions to people's role or requirement, and it has a monetary impact as well, it is worth making sure not just to make those changes verbally, but making a note of that, and also keeping an actual record, as Mirik said, it's like timesheet or...
Generally keeping records in writing is the best practice.
Absolutely.
So every time, if there is a verbal conversation, make a note or send an email. Nowadays, email is a form of a letter. I think letters became obsolete slowly, especially when we have now AI. I think it's email is the main communication now, probably. But sometimes it may be WhatsApp messages or text messages.
Yes.
So you need to watch out what any written correspondence is record.
Yes, and I would say that, you know, setting up a system of how those written correspondences are maintained is a good idea rather than keeping an ad hoc basis, because that will protect the business. It's just being organized in advance so that if there is a comeback, you have your evidence to support that you're not failing, rather than
I think it came to my mind, having good sickness absence policy would resolve it, because if the employee is not following the way the employee should report his or her sickness, then the employee is not at fault. It's the employee not following the policy. So then if there is a good genuine reason not to pay the statutory sick pay, then it's all fine. It's legal.
Yes.
Okay. And I imagine as well with communication on WhatsApp, with sort of the increased time limits and stuff, and increased court in tribunal cases, it's also important to make sure those messages don't get deleted in some way, because I imagine that can happen quite a lot and lead to issues down the line.
But also a lot of WhatsApp groups are being set up with, you know, automatic deletion being set up as a standard. So if there are WhatsApp messages being exchanged, ensure, and that's what I meant by saying, well, you know, make sure there's a process of how these written records are maintained, because it's well and good to say, well, I'd sent a WhatsApp message, but if the WhatsApp message is gone, then there is no evidence to support it. So really make sure in those circumstances a screenshot is taken and saved somewhere, you know, on the personnel file to ensure that that's available later on.
Okay, and moving on to our sort of final area for questions is the trade union protection recognition. So Navi, we've got the sort of bullet point headlines there, but could you talk us through what are the new regulations and how they're going to exist from when this bill's passed in 2026 and 7?
Okay, so I mean, trade union protection and recognition, generally speaking, at the moment is more limited to bigger organizations. It doesn't usually seem to be impacting small organizations. Small to medium organizations, medium-sized organizations. But with the changes that the government is proposing, it is likely that it could impact small organizations as well. As a starter, there is a requirement for employers to provide union representatives with access to office and meeting spaces as well as internet during paid time off, so they can carry out their union duties and training. The other thing that the bill is going to do is when an employee joins, the bill requires the employer to actually inform the employee that they have a right to join the union. So it's in the past, it would have just been employees getting to know about unions and joining, whereas now the employer has to tell them, well, if you wish, you could join a union. So and so that's a big, in some ways, a big move towards providing.
Well, I was thinking, Navia, how this is going to work in practical terms, because I think you may have like a ready template welcome letter or welcome email, where you just include within the wording this sentence, because like there is a the question is how do you convey the message? Does it need to be verbal? Does it need to be in writing? What is the evidence of it?
It doesn't, and I would probably not even put it in a welcome letter. What I might do is I might put it in the contract of employment to say you have the right to, join a union. So, and the reason why I'm saying is not necessarily, it is for the employee to read the contract fully, and for the employee to decide whether or not they sort of join a union. As long as the employer has complied with their requirement of making the individual aware, that in my view. I mean, again, we don't know what exactly the bill is, how that would be as part of the bill, but as long as the employer has complied with their requirement, they're not required to chase after employees to say, go and join a union, go and join a union.
Absolutely not. I would not do that. I would just, what I'm trying to say, I'm just trying to say to include somewhere a small print
Absolutely.
rather than just be very vocal about it.
Absolutely agree. And that's why I'm suggesting maybe contract, because contracts tend to be a long document and will have an element which covers the employer's perspective in terms of providing information. Also, it means that the employee is obligated to read their contract properly, so they should be reading their contract properly. And if they wish to join, then they can join union. And then the employer will provide them access to union representative if if they've joined a union and they want their union representatives to come in. Even in that situation, I think the employer will have to give them some space to sort of have this whatever conversation they want to have. If there are union, a person who's employed by them and is a union representative, they will need to give the space for access to office and meeting spaces as well for them as well, and internet during paid time off, so they can carry out their union duties and training. So that's the aspect that's more onus on employers in that respect. There is currently a 50% threshold for strike action. Again, generally it applies only to big organizations and mostly to organizations like NHS or councils, or it could be big airlines, etc. But given the changes that are being brought, it may apply to smaller organizations as well, but they're removing the requirement for 50% threshold for strike action. So 50% of members in the past had to agree to a strike action. And if that is now removed, a smaller proportion of members wanting to go on strike could initiate strike action. I'm not sure that is very helpful from economy perspective, but it is what it is, the proposal. And then there is a possible reduction. So at the moment, you need 10% of workers to sign up for to join a union in a workplace. So for a union to exist in a workplace, from recognition perspective, I suppose, you needed to have 10% of the workforce signing up. You needed at least 21 employees and 10% of workforce signing up. But that 10% is likely to change. We don't know whether the number of 21 is changing or not at the moment, but the proposal is that the 10% would be reduced, and it could be anything between 2% to 10%. So if it's 21 people, and if let's say it's gone down to 2%, then literally one person could sort of just one person wanting to be part of union would mean that the union has to be recognized by the employer.
I mean, the main difference here, just to note, is anyone can join a trade union now.
Yeah,
that they've got the right to join a trade union. However, if there is less than the certain number of employees, the union is not recognized at the specific workplace. So the difference will be in that the union may become less easy to be recognized, while now it is not. However, in practice, in my mind, it may work. Probably maybe more changes for the bigger employers, because for the small business, I would say that this may not have that big impact, but we'll see.
Potentially, Marek, but what it does is it means that employers will have to, with very small number of employees wanting a union to be recognized within their workplace, the smaller businesses would probably still need to recognize, even with say one or two people being part of the union and wanting union recognition, that would give the unions with that particular employer more negotiating and bargaining power. So as you said, people can more access to the employer in that sense, and to negotiate on behalf of the members or employees.
And
And then finally, sorry, did you have a question,
I was just
James?
going to add with employers having the onus to say that people can join a union when they start, that could create issues if people think straight away, oh, this is something to do then. This is part of.
Yes. I mean, the only thing I would say is that in the recent past, because of the way unions have been impacted with various different things that have come in force,
Mhm.
the unions' strength seems to have been diminished in the past. So they're not as proactive as they were, say, 10, 12 years back. But whether or not this will bring, start sort of getting the unions back in the form that they were, say, 15 years back, don't
Mhm.
know as yet. But there's that element is there that people are not happy with. But so employees, from what I gather, a lot of employees are not happy with how the unions are dealing with their matters when they have an issue. So in those circumstances, I would think that with people being disillusioned by how the unions manage their cases, they may not be so inclined to joining a union. Not because the law doesn't provide the support, but because the unions have been rubbish. So that
Yeah.
may be, that may be of assistance for the time being for employers. But in terms of removal of the other changes that the new regulation would bring, there is a removal of 12 weeks time limit. So after strike action, employees are protected for a 12-week period from being adversely impacted because they've taken strike action. The proposal is that that time limit would be removed. And if the time limit is removed, and it's sort of, I don't know whether there will be a time limit of any sort that would be provided, there is scope for argument by employees to say, well, anything that happens is linked. So even if it happens, say, 1.5 years after the strike action, is there potential for employees to argue that you've done this only because I had, taken strike action? Having said that, it will. I would think that the employee will still have to show that it is in fact linked to the strike action. That the reason the employer has dealt with it in that particular way is because, or has treated them adversely, is because of the strike action. But there is that potential for people to argue even after a prolonged period of time.
So
So, sorry.
I was just going to say, does it come back to that keeping the records again, making sure that everything's done sort of by the book
By the
almost?
books and making sure that you've documented the reason for any actions or any adverse action as an employer may consider, setting it out clearly, which would sort of show that it is not linked to any strike action. It is purely because of some conduct or capability, rather than giving the employee an opportunity to argue that it is because of their strike action.
Okay.
Yeah.
And Merrick, do you have any comments on how this will work, the new union rules, what beyond what's been said?
Well, as we've explained already, it may be much easier for the employees to unionize or to getting into a union or the union to be recognized at the workplace, and that may have some impact how the business is run, because then the business would have to provide certain provision for the members of the union. But obviously, how this is going to work in practice, we will see. And
Yeah.
best practice is really to keep the records, do everything according to the ACAS code of practice, and to the new employment rights bill will come. We'll see what else is there. Because I think now everything is very, very liquid, and there's a lot of discussion from both sides. Or from all sides. I don't know how many sides we're talking about.
Yeah.
It's just been to House of Lords, and then it was sent back to the Parliament. So we'll see how it's going to go.
Okay, great. Thank you. So just moving on to some questions. I see we've had one in the chat already. Be sure to add any more in if anything has come to mind. So could you explain the day one rights, please? So Navia, since you mentioned it earlier, could you just go through, expand on
Yes.
what you said?
So at the moment, an employee has a right to bring a claim for unfair dismissal. You know, if they, sorry, at the moment, an employee can only bring a claim for unfair dismissal if they've had 2 years of service.
Yeah.
If they've not got 2 years of service, they will not be able to bring a claim for unfair dismissal. However, when the bill comes in force, and this particular aspect of the bill is likely to come in force from sometime in 2027, the day one right would be implemented, which means that from the first day of their employment, an employee will be able to pursue a claim for unfair dismissal if their employment was terminated. So somebody walks into the office for whatever reason, if their employment was terminated on the first day or the 10th day, they will be able to bring a claim to the employment tribunal for unfair dismissal, and they no longer need a period of, say, 2 years before they have that right. So that will put a lot of onus on employers in terms of ensuring that any dismissal is done in a fair manner. So that's how I would that's what the day one right means. There are other aspects of day one right, not just about unfair dismissal. There'll be day one right for people to go on parental leave, etc. But it's a whole host of areas that people will have day one right for. But in terms of dispute, that day one right is with regards to unfair dismissal, which potentially opens the big door for people to bring, a big door for an increase in employment claims. So yeah,
So
it's
it
just
makes it
sorry
even more important to get the hiring right, to make sure you're getting the right people in, so
that
that you don't have
yes,
that issue straight away.
absolutely that, but also it doesn't. I know it sounds really scary that they'll have a day one right, but what it doesn't take away is that there are various fair reasons for dismissal. So as
Sure.
long as you do things in the right way, make sure that it is not a dismissal by text. You know, we don't think you're a good fit. Thanks. Bye. That's, but if you explain why somebody is not a good fit, because they're not performing, they're not, coming late every day, or they're disruptive in the office, whatever the reason may be, as long as they fall in the fair category, such
Yeah.
dismissal is likely to be fair. Also, it is important that you have a policy in place as to how dismissals will be dealt with or disciplinaries would be dealt with, and you follow that process. You ensure you're not in breach of ACAS code of practice as well, so that even a technical unfair dismissal cannot be brought against you. So it does put a lot more onus on employers in that sense, but where people could have got away with not following processes properly, not dealing with things appropriately up to the first 2 years, it just puts a lot more onus in that respect.
There were more questions, Navia, about this. If you look at the chart, because
I'll just read one out for you now. So I've got, with the introduction of day one rights under the bill, do you anticipate an increase in discrimination claims from applicants who are not hired or from very short service employees? And what practical steps can employers take during recruitment and onboarding to reduce the risk?
So during recruitment process, again, I would probably say that you should make sure that you've, the reasons for somebody not being successful is being set out clearly, documented clearly at the employer's end. So if a claim is being brought, you can demonstrate that it has got nothing to do with somebody's disability, but it has got everything to do with the other aspects of their not being able to deal with or not performing in the interview process or the selection process at the level that they were required to perform. In terms of initial recruitment process, ensure that if there's a request for reasonable adjustments, if somebody's made you aware that they've got a disability and they require reasonable adjustments, do consider whether that is the request is one that amounts to reasonable adjustment, and that those adjustments are provided. So in terms of the initial recruitment process, I'm not sure that the day one right would impact in terms of an increase.
I think it will stay. It will stay the same, because
exactly.
Not much will change. I mean, sort of like one of the examples which coming to my mind, and it's sometimes employers don't know what to do, is, for example, if they recruit a female employee for a certain job, and then the female employee inform them at the second day of employment that she's pregnant. And then I had cases when then they try to terminate the contract for various reasons. So obviously this is a pregnancy discrimination claim, and unfortunately in that situation, the employer dismissing that employee is risking quite massively a claim for pregnancy discrimination. So that's a situation. But then if someone is, let's say, being employed, and then in the second day the conduct is completely unacceptable, the person is not disabled, does not have any protected characteristic, then following the dismissal process and to sort of show that the dismissal is fair, that can be done. So that's a different situation. And I think also we still don't know, but the bill is sort of deliberating situations where there will be some extended probationary period within. So this day one right is sort of being debating still. Is it really day one, or is it going to be within 3, 6, or 9 months that were less sort of, it will be easy to dismiss the employee rather than not. So that's a question as well.
Yeah, no, I mean, to go back to the question asked is, would that increase in discrimination? Would discrimination claims increase as a result of day one right? The answer would be no, because the day one right is really more relating to unfair dismissal.
Yeah.
Discrimination claims are, even at this time, in present day time, is an exception to the 2-year rule. So if I'm advising any businesses about any dismissal, even where people have got less than 2 years service, I would always make sure that the business is dealing with it in accordance with ACAS code of practice, and ensuring that the real reasons are clearly set out to avoid any claims being brought by the employee with regards to discrimination, whistleblowing, or automatic unfair dismissal for asserting their statutory rights.
Absolutely.
So even though at the moment we've got 2 years service requirement, it does not mean that the employers dismissal anyone could just be free of any fear of claims being brought against them. No, the fear would be that the risk is still there, is if these individuals fall under certain protected characteristic, or if these individuals have blown the whistle, etc.
And then there is a next question which follows the first one. You can read it, James.
Sure. And they can make their claims in 6 months minus a day. So it could be the case that someone walks in, for whatever reason they get terminated on day one, and then you still have 6 months where they could pursue the claim.
Yes, and I'm assuming that although the Employment Rights Bill is extending 3 months to 6 months, in reality, at the moment, what is 3 months minus 1 day is actually more than 3 months minus 1 day by at least 6 weeks, because there is a requirement for ACAS early conciliation process, which lasts for up to 6 weeks. And then you have another month to issue the claim. So at the moment, you're looking at 5 to 6, 5.5 months from the date of the incident for a claim to be issued in the employment tribunal. that process is going to essentially get extended by an additional 3 months. So you've got the whole thing hanging over you for perhaps about 9 months, 8 to 9 months in terms of the process. And with how the tribunals are overstretched at the moment, some of them are overstretched. You may, even if a claim has been brought against you, let's say it's been brought against you at 31st of August, the tribunal has received it, but has not had chance to process it and send it out to the employer. They take 3 months to send it out. So you could receive a claim in a year's time for somebody who'd been with you for 2 days. So it is very important to ensure that record keeping is improved.
Yes.
I think there are more questions in Q&A section, James.
Yeah, I'll just get to that now. So can you explain a process to ensure the regular support to individuals about their working conditions, for specifically remote working, so to reduce any claims that may come forward? So if that's about, is there any, I'm guessing, what do you need to provide for remote workers especially?
Marek, are you going to answer that? Do you want me to answer that?
Well, I think, first of all, you need to provide all the same employment contract and enhanced and handbook and everything else as to any regular employee, right? Obviously, the place of work would be any location of the person being at the location. So it may be they home, or it may be they hot desking, or they own office. It depends. But I think the usual question which come up maybe is the employer responsible for health and safety and making sure that the place is being prepared for work. From what I've read, is rather the employee's responsibility than the employer's, because it's their premises. So employer does not have rights to change a specific accommodation and house of the employees. That's the sort of agreement. They do agree to work from home, and in a way they do agree to make sure this is sufficient. I mean, sometimes, for example, they may request a chair if they do work 8-10 hours in front of a computer. They need a really good quality chair. They can request this, or some other equipment which the employer very often should provide reasonably to the employee. But that would be the same case if the employee would be in the office.
Sure.
Yeah, I mean, I would add to all of that what you've said, Marek. In terms of the process to ensure the regular support, I would say one of the things that the business can do is make sure that they have some kind of a policy set out for remote working to start with. If they have a policy that clearly spells out what should be or how it should be done, then it will assist the employer and the employee to understand what the remote working condition in that particular business would be, because the requirements may differ from business to business. So it will not be one, a blanket policy that will apply to all employers. But what can be done in terms of providing regular support so that people don't feel alienated? Because when people are working remotely, and if that's the regular pattern, let's say they work remotely 5 days a week, and they don't really have, there's no requirement to get into work. I think that has an impact on people's mental well-being as well. So one of the things that could be done, in my view, is when contractual remote working is agreed, there is some provision for perhaps individuals to come into the office on a particular day, at least once or twice a month, something like that. So there is more interaction.
I would agree with this, Nara. What I would say, what comes to my mind, is usually the hybrid working may be the best option, or at least make sure that in the contract you say that the employer has got rights to ask the employee to attend the office or specific location if there is a business need or requirement for it, even if the distance is quite long. But that obviously depends on the type of what type of remote working it is.
Yeah. But again, if that is not a hybrid working or that is not possible, the other thing that can be done in terms of providing support is arranging for away days and arranging it well in advance, either as a team away day or the entire office away day, depending on the size of the business. And that again helps with team bonding, making sure people are performing better. And there is a different kind of support. People are not feeling alienated. This is more from mental well-being and bonding of employees within the organization. But in terms of ensuring support, work support, what I would say is that having regular online meetings, team meetings, video meetings, is a good idea to ensure that people are being kept in loop, they're being checked on, and their well-being and health and safety is being monitored to a degree, at least. But also it gives the employer the opportunity to make sure that they're performing correctly and to the required standard. The other thing I would probably add to it would be to say that there should be provision or it should be explicit to the employees that they can reach out to the employer virtually or in person, if they need. So the clarity that they're not on their own if they're working remotely should be there to ensure a proper two-way interaction between the employer and employee, and that will help the employer to keep an eye on what work is being done and how things are being done, but also allows them to provide the required support that employee will need. Does that answer your question, Ranjana?
Yes, those said amazing. So I think that's all the questions we've got at the moment. So I'll end the webinar here. But if you have any further questions or anything springs to mind, then please contact us at enquiries@truthlegal.com. I'd like to say thank you to Mirka Navia for taking us through the resolving employee disputes, and thank you everyone for attending.
Yeah, thank you everyone for
thank you. Thanks.
Yeah.
Thanks.